Hello, everybody, and welcome to our introductory lesson in a brand new series on the law of genocide. Now, essentially, what we're going to do in this lesson is just provide some introductory elements to this particular topic and explain the scope of this series of lessons, as well as examine why this is such an important topic and why it's such an important topic that is limited to just this particular crime. Because, of course, we have done international criminal law already. We've done a number of lessons on that subject where in international criminal law, you study four substantive crimes for the most part, and then you study a number of principles that is established by things like the ad hoc tribunals and the International Criminal Court. Whereas this series of lessons is going to be focusing specifically on one particular crime and one particular element within international law. So we'll explain why that's so important and why that's so interesting and why I'm doing this series of lessons in and of itself anyway. So, like I said, we're going to take an introduction to the subject of genocide, looking at what it is, how it is defined in this lesson as well. Bearing in mind that we will be looking at how it is defined in more detail in a couple of future lessons' time too, because of course, one of the controversies of the issue of genocide in both international law and within sort of geopolitics, sociology, and history is that the definition of genocide is not universally agreed upon. So there is something of an argument to have differences in definitions, challenging definitions, and really a whole series of articles and books on genocide studies has been dedicated and devoted to the question of what is the actual definition. So let's just take a step back and think, what actually is genocide and why is it important? So the word itself, like I said, is difficult in the sense that it is defined in a number of different ways. It means that there can be potentially political definitions. There are socio-historical definitions, there are anthropological definitions, and obviously because the subject of this series of lessons and because of the channel that this is hosted on, there are also legal definitions. Now, the position of genocide in international law and international politics as the idea of it being the sort of quote crime of crimes, if we're to quote the title of a very good book by William Schabas, presents itself in a very interesting way, because no longer are we just thinking about genocide from the perspective of finding a legal definition and treating it like a legal definition and treating it like a legal issue that it is. But we're also thinking of genocide from a political perspective. We also think of it from an advocacy perspective. And one of the famous things that we see, an article that that I read not long ago, in fact, that speaks about atrocities taking place in Africa a couple of decades ago. They spoke about how the use of the word genocide meant that more attention was poised onto that particular issue. That when you say war crimes or when you say crimes against humanity, people don't. They're not as attracted to that particular topic than if you were to say and call it genocide, regardless of whether or not something is or isn't genocide. And so this presents ourselves with an interesting idea about what genocide is, why it's important, and why it transcends more than just the legal and historical definitions that we have given it. So, generally speaking, then, while we define genocide broadly, we also have to come to a more specific legal definition, because law has to be at least a little bit determinative. It has to be at least a little bit able to have some kind of structure and foundation that provides us with a strict, rigid definition. Because if not, then the Genocide Convention and the actual idea of genocide within international law becomes meaningless anyway. And so this is really where I'm going to begin. And we're going to be speaking as if the legal definition of genocide is the only definition of genocide, at least for now. We might touch on some of the sociological and historical and arguments for why things ought and ought not to be included in the definition. And we will obviously be thinking about the idea of challenging this definition at various different stages as well. But generally speaking, I tend to always advocate for presenting the legal definition of genocide for a few reasons. Firstly, it is the definition that is most legally accepted. It is the most broadly accepted as well by states and non-state groups worldwide and throughout history, or at least throughout the last 80 or so years since the convention had came into force. And so with that, we can see a certain amount of determinability about it. We can clearly see that it is determinative in the sense that it is able to be defined in this legal sense. It is also the only definition of genocide that can be enforced against states and against individuals in the context of international criminal law. Given that the genocide definition that is outlined in the convention is also the same definition that was presented in the charters for the tribunals for the former Yugoslavia and Rwanda, as well as the ICC, the Rome Statute. It means that if you want to think about genocide, then, and you want to think about actually trying to achieve justice to victims of genocide, then you have to use this legal definition because, of course, law is what is enforced, not politics necessarily or sociology. Again, these are all controversial questions and controversial points to be made. But in terms of a general definition, we can all sort of colloquially understand what genocide means, regardless of whether or not we're talking specifically about the convention definition. So genocide is the deliberate and systematic destruction of a group of people based on their ethnicity, religion, nationality, and other defining identity traits. One of the things that is important here is that the general characteristic of genocide is that of the targeting of groups rather than the targeting of individuals. And so it doesn't place the individual at the front and center of the consideration for genocide. Obviously, individuals are killed or treated in inhumane ways, and that constitutes the acts of genocide. But the main focus of the Genocide Convention is this idea that these people are trying to destroy a group. They're trying to destroy a group of people, and that group is defined by ethnicity, maybe religion, maybe nationality. But whatever that definition is or defined by, the point is that we're talking about groups. Now, the term was first coined in 1944 by Polish Jewish lawyer Raphael Lemkin, who basically combined the Greek word genos, which means race or tribe, and the Latin word cida, which means to kill. So, for example, infanticide is the killing of children, or homicide is just the killing of people. And so what this was in response to was this idea of trying to define the events that were taking place during the Second World War, committed by the Nazis during the Second World War. By 1944, it was pretty clear that the Holocaust was taking place. Now, the extent to which the Allies knew of the scale is, of course, debated. It is probably unlikely that the Allies knew truly of the scale of the violence and the atrocities that had been committed. But at the very least, you have people like British Prime Minister Winston Churchill claiming that what is taking place in Europe is a crime without a name. And so really what we are looking here, and what Lemkin's basic mission was to do in this particular case, was to give it a name. And the name is genocide. Now, we will get back to Lemkin in future lessons' time, and we'll get back to his advocacy at Nuremberg and his advocacy in the 1948 Convention. We see that essentially, while the word genocide arrives in 1944, and while the prosecutors in the Nuremberg military tribunal, the International Military Tribunal at Nuremberg, used the word genocide at various different stages. It was not a defined crime in the London Charter. It was not a defined crime that was part of the sort of jurisdiction of the tribunal. Rather, genocide comes afterwards, and it is only really in the 1990s when we see the Akasu case in the Rwanda tribunal that we start to see the actual prosecution of an individual for genocide. So then, in this finishing off this series of this lesson specifically, then let's just think about the legal definition. This is the Genocide Convention of 1948, or as it's aptly titled, the 1948 Convention on the Prevention and Punishment of the Crime of Genocide. It is Article 2 that defines the crime of genocide, and it defines it as follows. It says that in the present convention, genocide means any of the following acts committed with intent to destroy, in whole or in part, a national, ethnical, racial, or religious group as such. And then it starts to define the acts. There are 5 acts that can constitute the acts of genocide. First of all is killing the members of the group. Secondly, we can think about causing serious bodily or mental harm to members of the group. Deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, imposing measures intended to prevent births within a group, and then finally the forcible transferring of children of one group to another group. So, there's a few things that we're going to unpick from this. Firstly, it should be noted that the most important distinction between, let's say, genocide and crimes against humanity, and another crime within international criminal law, isn't necessarily the acts. In fact, there is a lot of overlap between crimes against humanity and genocide in terms of acts. So, for example, killing a member of the group could be genocide, or it could be a crime against humanity. It could be either. It could be both in that kind of sense. And so the thing that we are focusing on for genocide isn't the act of genocide, the acts themselves. Generally speaking, we will look at some of the cases as well, some of the cases in the tribunals and some of the cases in the ICJ. We see that showing that these acts have taken place is a relatively trivial task. It's not the most difficult task to do, because often in a conflict situation or in a particular humanitarian crisis, there will be ample amounts of evidence that can show that an individual has or a group has killed another group or members of another group. The purpose, though, is that those acts have to have been committed with a very specific intent. It is the intent to destroy in whole or in part. And this is sometimes known as the dolus specialis. It's a very special intent, to commit genocide. And we will look at how the standard is defined by the courts in future lessons and why this standard is so high, and potentially provide something of a justification for a standard that's so high. But in addition to that, it also has to be the case that not only they are trying to destroy with intent, a group, but it has to be a very specific group. It has to be a national, ethnical, racial, or religious group as such. And so this brings with it a few challenges and controversies, because there might be a number of issues with this interpretation and with this definition. So, for example, one of the most difficult and controversial parts of the crime of genocide, not including political groups as a group that would form part of the sort of protected groups into the definition. Why not political group? In fact, the Nazis, when they came to power in 1933, with the passage of the Enabling Act, and they started to essentially implement their racial and ideological fascistic policies, political groups were some of the first to be targeted. In fact, a lot of the work of the Einsatzgruppen following the invasion of the Soviet Union in 1941, these were commandos that would go behind the Wehrmacht, and they would go about liquidating villages and shooting people. They killed about 500,000 people this way, and more than just Jews and travelers and other people of that kind of nature. They also were seeking out to kill Bolsheviks, or to be killing like sort of communist intelligentsia. It became a political issue as well as an anti-Semitic issue or a racial issue. So political groups, for some reason, are not included in the definition, despite the fact that they are definitely included when we think about a lot of genocidal acts that have taken place, the Holocaust being one of the most prominent. What about the idea of cultural genocide? This is one that Lemkin definitely advocated for. Does genocide require the biological destruction of people, or can it involve the cultural destruction of a culture, the destruction of a culture by forcible assimilation into a different culture, or by spreading individuals out such that they cannot practice their culture in any meaningful way? Does this not constitute genocide? It obviously constitutes an injustice in a way, but it doesn't necessarily constitute genocide. Another question and challenge is, if the convention is about prevention and punishment, how successful has it been in that endeavor? At the moment, there are at least 2 or 3 cases in the International Court of Justice, one state challenging another state of genocide, essentially accusing one of the other. You have obviously South Africa and Israel, and you also have Myanmar and the Gambia. So those have been argued to constitute that what is taking place in both of those situations are genocidal, and that is a genocide that is happening. And yet, those cases aren't going to be decided, at least for another 5 or maybe even 5 or 6 years. It's going to be a very long time before those cases are decided. Don't forget the Serbia-Croatia genocide case, I believe, was initiated in the ICJ in the early 2000s. It wasn't until 2016 that a judgment was finally handed down. These cases take a very, very long time. So how is prevention being sought after and done under that particular timescale, especially when genocides take place not over the course of 10 years, but often over the course of a couple of years, maybe, or even less time than that? The Rwandan genocide was only 100 days, in which some of the most incredible amounts of violence had taken place. So prevention and genocide prevention, one of the other strands of the convention, is also a very interesting issue related to genocide. This intent to destroy in whole or in part, is this standard too high? If you were to ask any state, depending on which case they are referring to, you would probably argue that they would probably argue the answer is yes. So it's a very weird political dynamic that we have here, where you have 2 cases taking place relating to, at least at the time of recording, relating to the crime of genocide being committed, at least. You also have the Nicaragua-Germany case that is sort of tangential. But the Myanmar-Gambia case, in that case, a number of global north states have submitted arguments for wanting to see a lower standard for genocidal intent. But then when we look at the South Africa-Israel case, it is states from the global south that seem to be advocating for more of a lowering of the standard of genocidal intent. So it seems that everybody is somewhat in agreement that the standard for genocidal intent might be too high. Is there a reason why it's too high? Or is there a reason why it is so high, should I say? Should it stay that way? Should it be lowered? What are the consequences of lowering that standard down? What is the justification for keeping it where it is? I'll make these points in future lessons' time. And with that being said, then let's just go over the scope of this series of lessons, and then we'll finish. And I'll go through some reading and some further reading for you to go along with this series of lessons. So this is going to be something of an advanced study of genocide in international law. So this will go beyond what you would ordinarily study in a module on international criminal law, for example. And this is partially because international criminal law is not just focused on genocide. It's focused on other crimes and focused on other principles of international law, like, for example, the substantive procedural elements of the ICC. This is going to be an advanced study on the crime specifically of genocide. Okay, this is genocide law itself, or the law of genocide. And with that being said, because we're talking about genocide law, it is important that we cannot just focus on the legal. We have to think about social, cultural, historical, and political elements of the crime. The crime cannot be divorced from these other elements, okay? Even if we accept and we provide good justification for a legal definition and for the legal definition that is cited by Article 2 of the Convention. Even if we focus on this legal definition and go, right, this is the definition we're going to use, we still can't divorce it from all of these other subsidiary elements. And we will also talk about charting the future of genocide law, because at this time of recording, there is really there is nothing more important, at least in terms of looking at genocide in international law, than thinking about what genocide is how genocide law will look in the future. So with it being the case that in the next few years, 5 to 10 years, we're going to see 2 handing downs of cases in terms of genocide, and there are also other cases that are going around, and there might be even more cases coming to the ICJ in the future about the Genocide Convention. It seems that now more than ever, at least in the last 20 or so years, the Genocide Convention is most heavily being utilized, especially compared to a sort of a lull period between 48 and the late 1990s. This should hopefully be a series of lessons that's valuable to not just international lawyers or people who are studying international law, but people who also study genocide from a historical, political, and sociological perspective, but also for people who want to have a bit more of a nuanced contextual understanding of genocide. Rather than defining everything as a genocide, what are the steps that are taken to make a determination about what is and what isn't genocide in international law? So it should hopefully be of value for many different people around the world, I hope at least. And generally speaking, what we're going to do is divide this series into 3 main sections. We're going to first look at the history, okay? And so this is really where we will be focusing our time on people like Lemkin and people like Hochschlaterpacht and the Nuremberg trials and all of these different kinds of things. And also talking about the process of actually getting the convention into law, actually getting the convention to the General Assembly and into a particularly strong legal standard. And then we will talk about how the historical development takes place all the way through to the ad hoc tribunals, and then finally sits where we have it today in the International Criminal Court, as well as in the ICJ. We're then going to spend a little bit of time talking about the actual law itself, the law of genocide, the substantive law, talking about each of the different elements, the different groups that are part of the Genocide Convention, the intention, the standard for intention, the various different acts, the idea of as such, what this actually refers to in the definition of genocide, as well as Article 3, which gives you all of the other kinds of crimes that can be prosecuted in the convention. So not just the commission of genocide, but what about incitement to genocide? What about aiding and abetting genocide? All these different kinds of things as well. And then finally, we will chart the future and look at some of the challenges. We'll look at the challenges with intent. We'll look at the challenges of the idea of genocide in and of itself. There are some sort of theoretical, conceptual ideas about whether or not we as an international community should be focusing on the prosecution of people who target groups rather than the prosecution of people who target individuals. Are there any better ways of achieving international justice? Does the Genocide Convention actually have any utility whatsoever? And I will sort of throw in a thing at the end when thinking about this and looking at the idea of crimes against humanity, because from a personal bias perspective, I'm an individual who is much more heavily inclined to advocate for the use of crimes against humanity in the prosecution of individuals and in the achievement of justice for victims rather than genocide. And there are loads of reasons why I believe that is a better option, and why I think that the international community should move in that direction as well. And maybe we'll see that happening with a convention on crimes against humanity sort of rumbling its way through the International Law Commission as we speak. But that is something that I want to just focus on at the end of this series of lessons, just to sort of tie up the study of genocide law and looking at how the law of genocide is treated. So with that being said, let's just look at some of the citations and further readings. This will be on the screen at the end of every single lesson. Image credit is obviously somebody who had taken an image of a memorial site in Rwanda, the Rwandan genocide being something that we're going to spend a lot of time talking about. Now, I've divided this bibliography, the readings and the citations, into sort of 3 main sections. The first is the Interdisciplinary Study section. So I would argue that one of the most important books for those of you who want to just study genocide is the Oxford Handbook. It gives you a number of different chapters looking at the sort of anthropology of genocide, political elements of genocide, the legal definition itself, the interrelationship between things like genocide and ethnic cleansing, and then it goes into a lot of detail looking at the history of genocide. It talks about genocide in the ancient world, it talks about genocide in the 20th century, colonialism as genocide, and it talks about genocide taking place even into the 21st century. So that, as well as the comprehensive introduction to genocide, are both very good sort of generalized works. If you're somebody who wants to look specifically at the law of genocide, there's only really one book that I would recommend. There are two others that are cited here, but the one book that I would really recommend is obviously Schabas's Genocide, the International Law, the Crime of Crimes. This is from 2009. The law of genocide hasn't changed too much, as far as I'm aware, since 2009. Maybe with the inclusion of the Croatia case would have been a little bit more useful, but that is the book that you and anybody who is studying the law of genocide would definitely want to get their hands on, including a couple of others that talks about ethnic conflict and peace building, as well as the sort of justice, politics, and the rights at war crimes tribunals, which is another book by William Schabas. And then finally, there are three books looking at sort of historical, sociological ideas related to genocide. Martin Shaw's What is Genocide is also an invaluable tool for anybody who is studying such a subject. And then there are also a very recent collection of books, the Cambridge World History of Genocide, volumes 1, 2, and 3, will provide you with all the detail of the history of genocide that you could ever want to know about. So, history of genocide referring to, of course, the history of atrocities from the ancient world to the medieval world, all the way through to the sort of colonial period, all the way through to the 20th century and 21st. And then the final one that I would recommend, that I'm sort of halfway through right now myself, that that would always be cited in any history of specifically the crimes itself, is Philippe Sands' East West Street, the origins of genocide and crimes against humanity, where he charts a number of things really, but he charts the creation of these two crimes in international law. So he's talking about Nuremberg, and he's talking about the creation of Nuremberg. He's talking about, and he does it from the perspective of a number of different individuals whose lives seem to interconnect quite interestingly, and interconnect with his life as well, which is quite interesting particularly. So he talks about Herr Schlotterbach, he talks about Raphael Lemkin, he talks about Hans Frank, and all of these things sort of link together in quite an interesting interesting web. So all of these books are really, really useful, and obviously there are thousands of books, there are thousands of articles, there's a whole area of study called genocide studies now. I'm sure you could probably get a degree in genocide studies these days as well. So bear that in mind when thinking about doing some more further reading and going into a bit more detail. The final point I want to make is that this is going to be a series that is going to start fully and completely in a couple of months' time. So I tend to do an introduction video, get some people to see how to get the interest of this particular topic up, and get people interested in this particular issue and this particular series of lessons. And then in a couple of months' time, I'm going to start releasing them on a more regular basis. So bear that in mind when thinking about when this was released and when the next video is going to be released as well. So anyway, thank you everybody for watching, and I'll see everybody in the next lesson.